immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates and licensed immigration attorneys come together to learn, exchange information and stay current on US immigration developments. My name is GB Satusa and I'll be your host for today's session, Waivers of Inadmissibility in Family-Based Cases. Now, for many families, receiving approval on family petition does not always mean the process is complete. Issues such as unlawful presence, prior immigration violations, misrepresentation, or specific criminal concerns can create barriers that prevent a case from moving forward. In these situations, a waiver of inadmissibility often becomes the deciding factor between approval and denial. Waiver cases are highly fact-specific and closely scrutinized. Even when a qualifying family relationship exists, applications can stall or fail if the waiver is not carefully prepared and adequately supported. Understanding how waivers work, when they are available, and what adjudicators expect is essential for families navigating this stage of the immigration process. Today's webinar is designed to clarify how waivers of inadmissibility function in family-based cases, explain the most common grounds that trigger waiver requirements, and highlight strategies for building strong, well-documented applications that align with current USCIS and consular standards. To guide us through this important topic, we are joined by Stephen Berman, Esquire. Stephen practices immigration and nationality law from his firm's Chicago and Milwaukee offices. His work spans family and employment-based immigration, temporary visas, permanent residence, naturalization, humanitarian relief, removal defense, and immigration court and federal court litigation. He also advises businesses, investors, entrepreneurs, and families seeking lawful status and citizenship. Attorney Berman, we're thrilled to have you. Thank you for joining us today.
Welcome. Thank you for allowing me to help people.
Now, before we begin, a quick note for everyone tuning in. immigrationquestion.com is a public education and discussion platform. Attorneys who participate do so independently, and the platform does not provide individualized guidance or representation. To everyone joining us from Facebook, YouTube, LinkedIn, and other platforms, welcome. If you haven't subscribed yet, now's a great time. Grab your notepads and let's get started. Now, Attorney Berman, let's begin with the foundation of waivers in family-based cases. In family-based immigration cases, what are the most common grounds of inadmissibility that require a waiver? And how often do families encounter these issues unexpectedly?
Okay. Now, by far the most common, probably almost anyone listening to this knows, unlawful presence. And second, I'd say would be fraud or deportation. And then finally, marriage. Let me go into the subcategories: marriage fraud and fraud in a prior visa petition. So, unlawful presence comes up in times people wouldn't think. For example, I met with someone this morning who had deferred action status, a DACA recipient from the time she turned 18. Her presumption is no unlawful presence. What's the problem? I can leave and come back. Not so quick. Take a look at all the approval notices, and there are gaps. So when you file the application for an extension, your approval might not be at the same date as the prior status expired. Same thing if you're on an H-1B or an L or anything else. You can get a gap in the approval between the approval date and the date that the prior status ended, and you could have a period of unlawful presence. In the employment context, working without permission can be a period of unlawful presence. It can stop you from adjusting, and it can add up. And unlawful presence, there are requirements for that. They're not set out in the Immigration Act, and they can change any time. But if you do meet the definitions for unlawful presence, if immigration's made such a finding and you leave the country, you could be barred. And they work in the aggregate. If you have here, there, and the other, and it adds up to 365, you got a 10-year bar to coming back to the U.S. For non-immigrant visa, you may be able easily to get a waiver. For an immigrant visa, you need to have the appropriate anchor relative, and that means a parent or spouse only who is a U.S. citizen or permanent resident. Without that, there is no waiver. Can't get how much hardship there is. It's not going to happen. So it's something someone has to check and speak with an attorney because the definitions change and how that determination is made. It's not set forth the Immigration Nationality Act. It could change anytime. The other one is, which can trip people up, deportation. Someone's got a final order. They're married to a citizen, for example, and they file a 601A to get a waiver. Well, guess what? 601A waives unlawful presence only. If you need an I-212 waiver, you're not going to get the 601A, and they'll deny it. Sorry, I-212, let me step back. A waiver for deportations on an I-212, you can file that also before you leave the country, but it's got to be done in the right order, or you'll get a denial. And you might not get it for 4 years after you file, so you'll be wasting a tremendous amount of time, and you'll be at risk of being deported by force. So it's got to be done in the right order. First, I-212, which is filed with the local district director, and then, if and when that's approved, the I-601A unlawful presence waiver. That's something that can trip people up. It's really easy to make a mistake on that. Now, marriage fraud. That's for something that's come up within the last 24 hours for me. A client of mine lost their appeal. They had a marriage-based case. The immigration found that you don't have enough proof that it's a good faith marriage. Say, okay, we tried. It didn't work out. They get divorced. They try again. They get the green card, and surprise, when they're filing for naturalization, they are asked about the first marriage. And what was before, well, you don't have enough evidence, turns into, and we think your marriage was fraudulent. Well, we didn't have to make a finding before, but they can make it now. So you didn't think that would happen when you filed for your citizenship, but it is routine that they will ask about that, and a person can have their status revoked and be put in removal proceedings based on that. So that's something that can come up also. And getting waivers for that, generally speaking, there's no normal waiver for a marriage fraud. None of the typical waivers for fraud is under 212I, and for a crime is 212H, and there's other provisions too. There's no general waiver for marriage fraud. Marriage fraud means you can't get any visa in the future. Okay. But there is a form of relief in removal proceedings called a 237 waiver. So see a lawyer, and there are things you can do not to get deported. And so it can be done, but it's no guarantee that will happen. Okay. Other things that need a waiver that come up all the time, depending on where you live. Each immigration office is different. At the Chicago office, I'd say comes up less. In the Milwaukee office, it comes up just about always. If you're filing for a green card based on some kind of an underlying visa, you come into the interview, they will look at how did you get into the country, what kind of a visa did you have, and what did you mark on your application for that visa. Now, they've got all that information, but you don't. Maybe you do, maybe you saved it. A whole lot of people didn't save it, and a whole lot of people had a friend fill it out for them because they live in a country where people don't have computers in their homes, or they didn't have it back in the 90s, or just about almost any country. Very few people outside of the United States and Western Europe. So a friend filled it out for you, and they said that you were married to someone in your country. You're not married. They said you were working at such and such a job. You weren't working there. They make all kinds of other statements in good faith trying to help you get the visa, but unfortunately not true. So when you filed for your green card, you told the truth. You didn't know anything about the fraud, but it was a fraud, and you're responsible for it even though you didn't know about it, and even though you tried to tell the truth every step of the way. That can come up. Okay, even in silly ways. I had a case I can think of years ago, I think they were from Jordan. The person helping them with the forms marked down for 2 different sisters that they were working for the same employer. It wasn't true. One of them was still in school, but it doesn't matter. At the interview for the permanent residence, it was fraud. You lied to us, and we're going to kick you out of the country or whatever unless you file for a waiver. So it could be costly, and depending on the officer, being granted a waiver is harder than it was before. My perception is we're getting more denials than we used to. So the standards are pretty tough.
Right.
Okay, and especially,
No, go on, attorney.
Okay, no, that especially a lot of people are novices. They haven't spent their life working in immigration. I have, for good or for bad. Someone's a newlywed. Say, of course it'll be a hardship to me if my spouse can't stay in America. I'll kill myself. It's just terrible. I'll be so sad. Not going to fly. They write, or typically for someone not represented, they write a letter. I'm terribly sorry and embarrassed that I overstayed my visa. It'll never happen again. I'm a law-abiding person. That doesn't qualify you for a waiver. It's not relevant. Maybe it's because of the way waiver translates in other languages that it means something different than it means in English. But a waiver does not mean I'm so sorry and I repent for my bad deeds. It doesn't mean that. Not at all. What qualifies you for most waivers is proving a hardship to a qualifying relative. So the individual who needs the waiver, their repentance is not one of the factors at all in whether there's hardship to the qualifying relative. So those are some of the things that trip people up to begin with grounds of inadmissibility.
Yeah. Right. Now, when it comes to waiver eligibility, how does USCIS evaluate the concept of extreme hardship, and what factors tend to carry the most weight in family-based applications?
Yeah, let's go through that. They're the same, the hardship factors and discretion factors are virtually identical. So let's go through that. The one thing to keep in mind at the outset is if you can prove your spouse will suffer a terrible hardship if they have to relocate to your country, but you can't show they're going to suffer any hardship if they stay in America, you don't have a case. Because if they're not going back to your country, the fact that they have a hypothetical hardship that's not going to happen won't do anything for you. So they need a straight answer. Are you leaving the country and staying with your spouse or not? And if you make it ambiguous or simply not believable, the answer is going to be no. So that'll trip a lot of people up, including a lot of attorneys. So it matters, makes a big difference. Now, that having been said, let's go through the factors. They want to know the first factor, they want to know the applicant himself or herself. Although hardship to the applicant is not a factor, it is discretionary, and so you'll first want to address the family ties to the U.S., including also the length of residence in the U.S. sometimes. So basically, what ties do they have to America, particularly their U.S. citizen and lawful permanent resident relatives in the United States. Okay. The next thing they want to know, the qualifying relative. In other words, you need to show hardship to your parents. You need to show hardship to your spouse, sometimes your child. What are their qualifying relatives? What are their ties to the U.S.? What family ties do they have? So it could be, it's not unusual for the U.S. petitioner. They might have better ties outside the U.S. than in the U.S. And if that's so, the hardship to them is going to be rather difficult to show. So what are their ties to the United States in terms of family ties, the qualifying relative? Why is that second on the list, not first on the list? I don't know, but it is second on the list. So that would be the next factor. I might put it first on the list. Next factor, third. This is from case law, and this is the order they have it. And I would say if you're briefing it or putting your evidence in order, it should go in this order. The country conditions, the foreign country. And on that note, the applicants, relatives, and family ties in the foreign country, and the qualifying relatives, family ties in the foreign country. So that means general country conditions. For example, someone just asked me about Nigeria. What are the country conditions? Well, not a lot of people know, because Nigeria's got big cities and industry and exports and whatnot. How many people know they've got the lowest life expectancy on earth? That's pretty bad. But you want to know that, and you want to enlighten and print your evidence, medical assistance, and so on. You need to know what's going on in that country and why the U.S. relative can't live there specifically. Okay. The next factor, this is going to be important for a lot of people, financial impact of the foreign national's departure. So what's the financial impact? Well, are you going to lose your house? Are you going to have to quit your job because you got to carpool the kids? You lose your health insurance. Well, what else is going to happen financially? It could be absolutely crushing, and you need to document it. So you have to think about it carefully and go through all your finances and document that hardship. And then finally is significant health conditions. I would put a proviso on that. The fact that a person is very ill, they've got heart disease, and so I can't join my spouse in Mexico. Well, maybe Mexico has some very fine treatment that's readily available for heart disease. You'd have to show they don't. Otherwise, why can't you go to Mexico? That's what they're going to say, not what I'm going to say. It's not a matter of being heartless. It's a matter of you got to show why you can't go there. So health conditions, you need to go through that and need to explain why is that relevant to the hardship if the person is not allowed back into the United States. Okay. Yeah. And then one little footnote, but a couple little footnotes that are important. If the petitioner, the spouse, the parent, if they pass away, and it's automatically under 204L, the visa is automatically turned to a widow's petition, orphan petition. The death of the petitioner itself is deemed sufficient for hardship. So you can save yourself the trouble. You might need to file a waiver form, but the law actually presumes hardship in those cases. You can save yourself a lot of trouble. And then finally, hardship, maybe the person's not going back to their country. Maybe they're going to go somewhere else if they have to leave the US. Right now, they're not allowing a lot of third country processing, but some people, they might have been born in Pakistan, but they grew up in Burma. I don't know, whatever it is. Countless people were born in the Philippines, but they're living in Hong Kong. Doesn't matter, whatever country it is. You're processing in a country, you're going to move to a country where you weren't born, or you're not a citizen. So you got to show where you're going to go and what kind of hardship there would be there. Except one exception to the J visa waiver. If you're on a J visa, you got a two-year home country residence requirement. That's in the home country only. So that factor is for a J visa, it's got to be the country the person's got to return to.
Right. Now, supporting evidence is often the deciding factor in waiver cases. Now, what types of documentation are most effective, and what evidence is most commonly missing or overlooked?
Okay, this takes me back to what we said before. What's really critical for certain things like length of residence in the U.S. and so on, it's not enough to say so. They do have to say so, probably through an affidavit, but you got to document it also. You need tax returns or other documentation to show that. Also, relatives in the U.S., a list's not good enough. How do you show you're related to someone? Well, if it's a brother or a sister, you need their birth certificates that shows you got the same parents as you do. If it's a cousin, same thing. You need to document that these people actually are relatives. So people don't think about these things. They, well, why don't they just believe me? Well, they just believe you, then just say, trust me, I'm going to suffer hardship. It's not going to work that way. You got to document it. Regarding the documentation, exactly which documents they are, if it's a health issue, I would suggest not to submit you can get the person's health records and it'll be 1,000 pages and it'll be written in medical language, not mean anything to the person looking at it because they don't know what it means. It'd be a lot better to get a letter from the doctor. And a letter from the doctor shouldn't say, "Dear sir, madam, please forgive this person for missing work," which is what they'll give you, unless you make them do otherwise. A letter from the doctor is going to have to say, what is the diagnosis? What is the course of treatment? What's the prognosis? And what precisely is the foreign national's presence in the U.S. related to that? And how so? So that's got to be in the letter. It can be short. So instead of 1,000 pages, you got 1 page, that could be good enough. And you might want some, the list of the medications and so on. If the hardship is psychological, you want a psychiatrist report. And if the hardship is based on, you've got children here, it's not hardship to the children, hardship to the spouse, because there are children here and the children can't relocate. Well, you got to show you've got children, and you've got to document whether they're going to a private school because of their special needs. You've got to document it. Well, that's one of the things that a lot of people, they don't realize that just saying it's not going to be good enough, and a lot of the really basic things that you know about your life, they don't know, and they don't have to take your word for it. So you got to document things you might think are silly, like the report card from the school they're at, and what treatment they're getting at the school for their whatever it might be, and so on. Those things have to be there. It's not enough for your word. Another word on what's your word. If you're getting letters, you should be, from friends, neighbors, co-workers, employers, and so on. If at all possible, they should be under oath. If at all possible, read them. See if they relate to hardship. Typically, they will say, foreign national, whatever his name is, Francisco Rodriguez, whatever, is a great citizen, and he always pays his taxes and so on. It's not relevant. They don't need, first of all, you're not a U.S. citizen, and which people will say. And second of all, being a great guy, well, it's kind of nice, but it doesn't really show you qualify for the waiver. So you wanted to say something concrete and tangible. What hardship will there be to this individual? What hardship will there be to the relatives? So get the letter, the supporting letters, and make sure they're relevant. They're not letters recommending you for a date, not recommending for your job. They're about hardship. So read them. No problem helping people to draft them. Although if they use identical language, the officer looking at it will notice. So they should be real. And you're welcome to help the people because they might not have hours to work on it, and they probably appreciate your help in the process. Nothing wrong with that.
Right. Now, prior immigration history can complicate waiver eligibility. How do issues such as unlawful presence, misrepresentation, or prior removals impact the availability and strength of different waivers?
Well, sure. The unlawful presence itself is why you need the waiver. Misrepresentation is why you need the waiver. So that's a matter of identifying in advance whether you need it. Prior removal, you got to do it in the right order. You got to get that waived before you even file the other waivers. People don't realize they're self-deporting when they leave the country after an order of deportation. Say, well, I wasn't deported. Well, you were. Or you left after deportation, or you self-deported. So that's a matter of just be aware what grounds of inadmissibility are you causing when you plan the consular processing. Now, as far as eligibility for the waivers, that's why you need the waiver. The fact that those things happened don't prevent you from getting the waiver. Those are the things that can be waived. Now, the nature of the misrepresentation can make a difference. How bad was it? Or you said you were going to school and you didn't show up to class with an excuse. Why didn't you go to class? Well, it better be believable. It's a story they've heard 100 times. So the nature, or similarly, your neighbor filled out the form for you because you were 14 years old and they were lazy and they put down your sister's information. Okay, they can buy that, and you might not need as much evidence. Similarly with that and with a crime, with unlawful presence, if there's a legal doubt whether you're really subject to the ground of inadmissibility, in my experience, they're a little bit more willing to grant the waiver even with weaker evidence. The more extreme the crime, the unlawful presence, the more extreme that the ground of inadmissibility is, the more you got to counterbalance that by the evidence in the waiver.
All right. Now, timing and strategy are critical. What should families consider when deciding when to file a waiver, especially in relation to the I-130 or the I-485 or consular processing cases?
Right. The preferred way to do it in adjustment of status is file it with the adjustment. Why? Because if you don't, you'll get a notice of intent to deny and give you an extremely short time to scramble and get it done. And you might not do a great job the first time, and you don't get a second chance. If they don't like it, they'll deny it. If they give you 30 days to respond, that's your waiver. And they don't have to accept any evidence after those 30 days. So better to file it with the application. Even if you don't have all the evidence, you can always upload and submit additional evidence later. Consular processing, you can't file it until after the interview. And once you file it, they could take 3-4 years to process the waiver. Same thing when you're in the country, by the way, the 601A, 3-4 years right now. Outside of the country, same thing, even in ridiculous cases. I got a case in Australia from back in the COVID era. We filed for a waiver for the vaccine requirement. And it must have been 2021, maybe 2022. And great. We filed a great waiver, very believable, no reason it shouldn't be approved. But they're taking 4 years, 5 years, whatever. And even though you don't need the COVID shot anymore, you need all the other shots, and the person has a religious objection to it, well, you might have to wait 4 or 5 years. So it's consideration if you can happen to be in the US for whatever reason and file for adjustment. It doesn't mean you're not stuck in a foreign country you don't want to be in for 4 or 5 years. So that is something you definitely want to think about. They are very slow on the waivers right now.
Now, for applicants who have already received a denial or request for evidence, what best practices can help protect the underlying family petition and strengthen the waiver response?
Sure. So the underlying petition itself, the only time that a ground of inadmissibility will affect it is for marriage fraud. Otherwise, I assume the request for evidence regarding admissibility or the waiver, that's going to be on the 485. So you can get an approval on the I-130, I-140, and a denial on the 485. So you must file a timely response. If you can upload it, it's better. If you're sending it even by private courier, you must know that delivery is can take. You pay for an overnight delivery, it might not be 4 or 5 days. Even you're paying for it, it doesn't make a difference. There are all kinds of hijinks that can happen. And so you have to follow it very closely, make sure it's on time. Now, what's done, if you need to file a waiver, you're going to have to fee it in at the right place, generally at the USCIS, at the address for the waiver itself and not with the local office. And it's the local office that's giving you request for evidence, notice, intent to deny. So you need to pay the fees and you need to get it to the officer at the local office that's looking at it. I'll give you a couple examples of how that works in practice. I had a case where we had not the strongest waiver on earth, but the person had been arrested. They disclosed the arrest, but there were no records. And immigration came back, tell us more, what's going on? Why don't you have anything? Well, it turned out that the person was wrongly arrested and the judge let them out immediately, no charges were pressed, and they were even given money by the police department because of the incorrect activity that went on. The immigration, I think, was so shocked by that, they just said, okay, we've heard enough, and you're approved. Another case, like the other extreme, an arrest for a serious domestic violence issue, but the state chose not to charge the person. They gave no explanation, no excuse, no nothing. You're not inadmissible for an arrest. You're only inadmissible usually for a reason to believe you committed a crime, which maybe there was here, or for a conviction. And so the Immigration Service didn't even require anything. Good enough arrest. You got a prompt approval. It can depend on the officer. It can depend on, it's so individual. Each situation is so unique that it's hard to generalize. But the basics for everyone is it's got to be on time. Upload it if you can upload it. Pay the fees. You can't fee it at the local office. Fee it in at the USCIS, and make sure your answer is relevant. I would suggest if you did it pro se, meaning without a lawyer, if you get a request for evidence, notice of intent to deny, you need a waiver. I highly recommend you get a lawyer to do it. There are some people that are naturally good and understand what an affidavit should look like and how you fill out an application and whatnot, but they are few and far between. And people who are very educated and successful assume that they can do this too, and sometimes they can, and often they can't. Is there anything else?
Go on, Attorney. All right. Thank you so much for those valuable insights. Now, for everyone watching, waiver cases require careful planning, detailed documentation, and a clear understanding of how adjudicators assess hardship and eligibility. A well-prepared waiver can make the difference between prolonged delays and meaningful progress toward reunification. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage directly with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Berman, based on your experience, how do platforms like ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
Say it again. How do
platforms like ImmigrationQuestion.com help immigrants and immigration attorneys such as yourself?
Yeah, information's not always so accessible. AI is fabulous. They got a lot of good answers, but people's individual circumstances are so different that to get advice that you have a legal right to rely on and that it would be a smart idea to rely on actually requires more than that. It would be a good idea, definitely, to have a lawyer to help with a person's individual circumstances. And getting some of the basics through a platform like this, I'm sure it's very helpful for many people, and probably raises issues that if you don't think of them, you can't ask AI because it won't think of it for you.
Thank you for sharing those thoughts, Attorney Berman. Now, before we move on to our live Q&A, I have one more question. For families who feel pressure to move quickly after learning a waiver is required, what warning signs should prompt them to slow down and reassess their approach before filing?
Filing the waiver.
Yes.
Yeah. I can't think of any answer to the question. It depends on the circumstances. Sometimes a person might not qualify for the waiver and they're wasting their time and they want to back off and don't do the application. Give you an easy example of that. It comes up all the time. A person entered the country illegally in 97. They stayed till 2000. They returned to their country. They came back again illegally after winter vacation and continued living here illegally. And they want to file a 601A waiver for unlawful presence. But surprise, they're not eligible. They're a multiple violator, and they need to stay out of the country for 10 or 20 years, and then they can file for a waiver. So you might not want to go through with the process to begin with. How are you going to know? Well, if you don't know what to look for and what questions to ask, you're not going to know. That's precisely the type of thing where you might want to get legal advice in advance before you get started. I'm sure there are countless other examples of when that happens. You want to look at, are you getting yourself into more trouble or less trouble?
Now, if you've just joined us, we've been speaking with Stephen Berman, Esquire, on waivers of inadmissibility in family-based cases. We are now moving into our live Q&A session. This is your opportunity to ask questions directly to a licensed immigration attorney. Please drop your questions in the chat or call us live at 516-703-3483 and we'll take as many as possible. All right. If I have a criminal record from long ago, can I still get a waiver to stay with my family?
Depends on what the crime is. It depends on how you enter the country. It depends on a whole lot of other information. There are waivers for some crimes, so how long ago it was makes no difference.
All right. My spouse is a US citizen, so does that make waiver easier than if my spouse has green card?
I haven't seen that. I don't believe so.
All right. Can medical issues with my sick child help my waiver?
Yes.
My waiver.
Yes.
All right. Now, attorney, recent reports have highlighted increased reliance on INA Section 214B by consular officers, raising global concerns about visa refusals and discretionary decision making. Now, attorney, how should families navigating waiver and consular processing cases interpret this trend? And what does it signal about preparation and documentation standards today?
Okay. So assuming that it's not one of the countries that has a freeze on visa issuance, and assuming it's not one of the countries also that has a pause on immigrant visas or the various countries for the January 1st pause on immigration. Okay, assuming not that, it's just a regular case, run of the mill, and no other real bar is coming in to get a 214B, why would you get one now? There are other issues that are coming up now, and they're new and they're not highly publicized. The biggest one, I think, is public charge. So, for example, suppose you're from the Philippines. There's no bar on Philippines getting an immigrant visa, but you're an elderly person. How are you going to support yourself in the US? Why wouldn't you just go on welfare, which in fact you'll probably be eligible for? What are you going to do then? The US sponsor shows they make plenty of money. Great. Are they going to spend it on the parents to take care of their medical needs or whatever else? Who knows? Is this individual going to work? Who knows? Are they disabled? Who knows? All right, so that can come up. And so what do you do about it? If you anticipate it, you might want to have an advance proof of what insurance is available and what you've done to make sure the person's covered in America. That's just one example. It's important. So the public charge is in flux. They're coming up with new rules, and what worked in the past for the time being, it's not going to work right now. So you're going to have a lot more solid evidence of what your plan is, so the person's not going to be going on public benefits, even if they're eligible for the public benefits. Okay. Other 214Bs right now, the ones that I know of right now are ones because there's actually a bar or a freeze to the people coming into the United States, either based on security or based on public charge. So many of them, the interviews are going on. They'll come in for the interview, but they can't be issued the visa. They'll get a 214B. So even if it's successful, maybe the officer will be nice and say, well, we're planning to approve you. We just can't approve it right now. So what do you do about it? There's nothing to do about it. You can't circumvent that. There's no waiver right now. It's a pause until they formulate a policy. And so therefore, you just have to wait.
Yeah. All right. Thank you so much, Attorney Stephen Berman, Esquire, for sharing your time and insight today. Your explanation of waivers and inadmissibility helps clarify an area of immigration law that many families find overwhelming. And to everyone watching, thank you for joining us today. We hope this discussion helps you better understand waiver options in family-based cases and the importance of careful preparation. You can always visit immigrationquestion.com to ask immigration-related questions and stay informed about upcoming discussions. If you'd like to revisit today's discussion, the full replay will be available on Spotify very soon. Just search Borderless Talk by immigrationquestion.com. Join us Wednesday for another live conversation covering key immigration topics and current developments. Until then, stay informed and stay connected.